Room. Are we on the record?
Yes.
Okay. This hearing of the New Mexico Department of Health will now come to order. I would like to welcome you to the public hearing on the proposed new rule 7.35.2 NMAC, the New Mexico Psilocybin Program. My name is Craig Erickson, and I have been appointed by the Department of Health Cabinet Secretary Gina de Blasi to act as the hearing officer in this matter, and I will be presiding over the hearing today. Deputy General Counsel Chris Woodward will be advising the department in this proceeding, and Dominic Zerlo, Director of the Center for Medical Cannabis and Psilocybin, will provide a brief summary of what is happening in the proposed new rule and address topics raised in the written public comments that have been received by the department so far. Pursuant to this notice, this matter is being heard this 24th day of April 2026 via a live web-based video conference and via telephone. Also pursuant to notice, the public has been given the opportunity to comment on the proposed rule via the live-based web video conference and telephonically, and if you're here in person. The opportunity will also given to the public to submit written comments via email messages through the close of business today. This is a recorded proceeding, and the time is approximately 9:02 a.m. This proceeding is being held in accordance with NMSA 1978, Section 9-7-6C of the Department of Health Act and NMSA 1978, 26-2D7, which requires that the department promulgate requirements, restrictions, and limitations on the psilocybin program, as well as necessary training, safety protocols, best practices, and requirements for data collection. We'll proceed in the following manner. Dr. Zerlo will give a brief introduction regarding the rule as I described. Mr. Woodward will then move to enter the exhibits into the record, which will include the public comments that are submitted by you all. And then we'll take comments from each person who would like to make public comments today. And because of the number of people we anticipate may want to comment, we're limiting your time to 5 minutes. I'll remind those giving comments today that this hearing is being recorded. And before you speak, please state for the record your full name and who you represent if you're here on behalf of some entity, and you should come forward to speak at the mic. The department is not bound by the formal rules of evidence during these proceedings. However, I may, in my discretion, exclude evidence that is incompetent, irrelevant, immaterial, or unduly repetitious. I may also take notice of judicially cognizable technical or scientific facts within the department's specialized knowledge. And I think with that, we can move to the introduction to the rule from Dr. Zerlo.
Thank you, and good morning, everybody. Thank you for being here and being present. So the rule essentially covers the initiation and the application process for cultivators for medical psilocybin, transport of medical psilocybin, and the rules for applications and the starting of psilocybin testing laboratories. That rule has been published on the department website and also on the Sunshine portal. We did yesterday also post on the Sunshine portal a list of anticipated revisions, and for those who are here in person, we do have that list also in the back of the room. In brief, those anticipated revisions are for Section 7.35.27A1, revise the definition of actual control as follows. Actual control means the ability to control the policies, management, or personnel of a permittee. B, control strategic priorities, capital allocations, acquisitions, and divestments of a permittee. Or C, control a majority of voting rights of a permittee. And on the written document and also on the document on the Sunshine portal, there is explanation with regard to these. In case, just as a general, these are based upon comments that had already been submitted to the department. The second change is 7.35.2.7A2. Revise the definition of administration session as follows. 2. Administration session means the session in which psilocybin is administered. The third change, 7.35.2.7I2, revise the definition of inoculate as follows. 2. Inoculate means the process of introducing psilocybin spores or mycelium into growth medium. 4. 7.35.2.8, revise application submittal requirements concerning rental properties as follows. A. General requirements. An applicant for a producer or laboratory permit shall provide to the department and shall maintain the following records. Part 9. Proof of ownership of the facility or a signed written statement from the owner of the property acknowledging that the owner understands that psilocybin products will be produced or tested on the premises. 5. Part 7.35.2.9c. Revise restrictions on transferability of permits as follows. C. Permits non-transferable. A permit shall not be transferred by sale, assignment, or otherwise, except as approved by the department upon the death of a sole proprietor. The sixth item, 7.35.2.19e. Table 1, revise total yeast and molds action level from 20 CFU to 1,000 CFU. And as a note, that is the revision based on the recommended limit set by American Herbal Products Association for yeasts and molds in powdered dried food products. 7.35.2.19f. Specify that water content shall be less than 10% in order to pass water content testing. The eighth item is 7.35.2.26b. Specify that a courtesy copy of a notice of immediate suspension or notice of proposed disciplinary action will be transmitted to the permittee via email in addition to service via certified U.S. postal mail. And item 9. 7.35.2.19, Table 4, modify certain pesticide testing action levels as follows. And pardon me for my pronunciation, I do not normally pronounce names of pesticides. So abamectin changing to 0.15, bifenthrin changing to 0.1, and metrophenone had a misspelling, a typo in the name, and changing to 0.5. And those revisions are to correct typographic errors and to more closely reflect some of the relevant standards currently used. And with that, I turn it back to the hearing officer. Thank you, Craig.
At this time, Mr. Woodward will introduce and move to place into evidence the exhibits.
Can you hear me? This closer. Okay, so I'm going to go down the list of exhibits for this hearing, and these are posted online. We don't yet have these exhibits on the DOH Rules webpage, but if you go to the Sunshine Portal Rules hearing page, if you just Google the expression NM Sunshine Portal Rule Hearings and choose the first option, the exhibits are posted there under Department of Health, and it's under 7.35.2, and you'll see it in the list of documents at the end there. So we have a total of 9 exhibits to introduce. The first one is a letter from the New Mexico State Records Center and Archives. So because we were creating a new chapter, we had to request approval from the State Records Center and Archives for that. So Exhibit 1 is just the approval dated February 24th of this year, the approval by State Records for the creation of a new chapter. So this is going to be under Title 7, which is Health, and then Chapter 35, Medical Use of Psilocybin. Exhibit 2 is the proposed new rule, and that starts on page 3 of the PDF. Exhibit 2 is the proposed rule. Exhibit 3 is the notice of public hearing. That starts on page 22 of the PDF document. That's the notice of hearing for today's hearing with a description of the proposed rule and how public comments can be submitted. Exhibit 4 is an affidavit of publication from the Albuquerque Journal. And so this is an affidavit from the Journal just attesting to the publication of the notice of hearing, that it was published on March 24th in the classifieds of the Albuquerque Journal. Exhibit 5 is, let me find it. Exhibit 5 is an affidavit of publication for the New Mexico Register. That begins on page 26 of the PDF and continues. So this is just an affidavit attesting that the notice of hearing was duly published in the New Mexico Register by State Record Center and Archives on that same date. Looks like it was published. Yeah, it was on the same date as the Albuquerque Journal publication. Exhibit 6 is the letter appointing the hearing officer in this matter, Craig Erickson. This is dated March 5th and it's signed by the Cabinet Secretary Gina de Blasi. That's on page 28 of the PDF. Exhibit 7 is an affidavit of notice to the public. So this is an affidavit signed by Jacob Clark, attesting to the various things that the Department of Health has done to comply with the notice requirements of the State Rules Act. And that is on page 29 of the PDF. Page 30 is on page 30 of the PDF is Exhibit 8. This is the list of anticipated revisions to 7.35.2 that Mr. Zerlo was referring to, and there are copies available at the front if you're interested. Those, again, are not exhaustive changes, but they're just changes that the department knew as of this point that it was anticipating making. But we will be continuing to receive public comment through the end of today's hearing. And Exhibit 9 consists of the public comments themselves, so that begins on page 33 of the PDF, and as I say, we'll continue receiving those and include those in the exhibit. And so with all of that being said, I would ask that the hearing officer admit Exhibits 1 through 9 into the record of today's proceeding.
The exhibits 1 through 9 will be admitted into the record, and as indicated, if there are any additional written comments that come in today before 5 o'clock, they will be added to the record as well. At this time, I think we can open the proceeding to comments from the public, and I guess I'd like to ask Mr. Woodward to comment on how that will work in terms of offering public comments.
Okay, so Dr. Zerlo, would you like to speak to that?
Essentially, each individual, and if you're here in person, you would have signed in the sign-in sheet in the back. If you did not sign in to do public comment and would like to do so, you can still request that. We'll have people, we'll call them up by name, and we will just need to have people come up to the podium. If you have mobility issues, one of our staff will bring the microphone to you. So please just indicate that to us, and we're happy to help and accommodate. For those individuals who are online, once we have completed going through the public comment for those who are here in person, then we will open it online for those individuals to provide comment as well. And to do so, we just simply need to have you raise your hand within Teams, and then we will unmute you at that time. Once we call your name, you can then unmute yourself on your end and then provide the comment. So with that, we can proceed.
Okay.
And the first individual is Denali Wilson.
5 minutes, right? I'm gonna try and have a stopwatch too for myself.
And just to let you know, we do have a timekeeper on the side.
Oh,
with a
okay.
flashcard here
Oh,
to your right.
awesome.
So,
Okay.
So if you could state your full name for the record, please, and if you're representing someone, if you could indicate that as well. And be sure to talk as well as you can into the microphone so that your recorded post gets recorded well.
Thank you all. Grateful to be here this morning. My name is Denali Wilson. I am the State Director of Strategic Support for the Healing Advocacy Fund, which is a nonprofit that supports state-regulated access to psychedelic healing with a focus on access and equity within those systems. So I'm really grateful to have the opportunity to participate in rulemaking and want to move quickly through some things. I'm trying to be as responsive as I can to the anticipated revisions. So I want to start by talking about predatory financing and disguised control, which is an area where we provided feedback to the department. And I'm really grateful for the department prioritizing this and being willing to consider recommendations that we've made to improve these protections. You know, as a state, we have a really long history of economic exploitation and extraction, and I think we all have a shared interest in making sure that this not become another place where outside money and interests come in and take advantage of our people and our resources. I want to say that the amendments don't fully address this problem, and even with the changes to actual control, the regulations continue to still too broadly restrict ownership arrangements and risk unintentionally prohibiting things that are beneficial and legitimate non-predatory financing arrangements, while at the same time not protecting enough to prohibit more sophisticated arrangements of disguised control or other deceitful and predatory practices. Under the current draft regulations and under these proposed amendments, it is still unclear whether a party could, and if so, how they can invest in a permittee without taking responsibility for the compliance and actions of the permittee. And that given the lack of traditional investment vehicles that are available in this space, right, involving a Schedule I substance, we don't have traditional financing and banks. That lack of clarity would lock away needed capital, like even friends and family investments, out of local operations. We hope that there's an opportunity to continue to iterate on and improve these critical and foundational protections further in the rulemaking process. Really, we believe that the solution is not to restrict investment broadly, but to instead distinguish clearly between those who are exercising actual control over a permitted business and those who hold a more passive interest. And so we've offered some suggestions that reframe around these distinctions in order to strengthen protections for permittees in the program from bad actors while preserving access to what is very limited capital in the field. I want to move to another equity issue that we talked a lot about in subcommittee and also was a part of our written feedback, and this is the landlord attestation piece. I want to start by acknowledging that New Mexico is the first state to allow for non-property owners to operate within the cannabis industry, and that was a tremendous step in equity and access in the cannabis space and changed dramatically the national landscape. And I'm really proud to live in a state that modeled that. We also know that it created very new challenges, and I'm grateful that the department has taken an interest in making sure that we're protecting tenants. I think the amendment in this provision still needs work. Landlords, even those who are supportive of their tenants in the program, are unlikely to provide written approval to engage in conduct that remains federally illegal on the premises. And any attestation would amount to written proof in a legally binding document of aiding and abetting the manufacturing of a Schedule I substance. As As amended, there still is reference to a landlord acknowledgement of that activity, and I think that's going to be a major barrier. We think really there does still need to be a landlord, a lease option, and the department can specify that the lease must be protective of the tenant's rights to participate. That could include, model language of an anti-illegality clause that requires the landlord not to act on, or the landlord acknowledges that they won't act on their right to end the contract and the lease. I will end there and maybe come back if there's time.
And the next individual we have on the list is actually listed as a maybe, Michael Williams. No? Okay, thank you. Thank you, Mr. Williams. The next individual is Kate Hawk.
Good morning, Ms. Hawk.
Good morning.
For the record,
I'm Kate Hawk.
are you here on your own behalf?
I'm here on my own.
Okay, thank you.
Yeah, I just had a question that has come up about after all of the the things that are spelled out. There's just a comment about, or in the that says something about selling to practitioners. And we were wondering, as practitioners, the medical prescribers, is it the people who are referred to as guides? That was just a question. So I just wanted, I don't know if that's within the scope of what we're talking about today, but that was just a question that came up that we are wanting clarification on.
Would you like to speak to that?
Just as a note, the items as far as the definitions with regard to practitioners, guides, and with regard to treatment are not a part of this rule. They are there as placeholders at this time. And as the additional rule hearings, where some of those definitions are defined, that will be clarified at that time.
Okay, thank you.
Thank you.
And the next individual who has requested to speak is Hanifa Washington.
I'm going to forego, but if Denali would like my time, I would be glad to give it.
Okay, and for those who may not have been able to hear, Ms. Washington said that she was going to forego, but would be happy to yield it to Ms. Denali Wilson.
Is that all right with the department?
That's fine.
Absolutely.
Thank you, Hanifa.
And just while Ms. Wilson comes up to the mic, the next individual, just so you're prepared, will be James Ferreira.
Hi again. Again, Denali Wilson with the Healing Advocacy Fund, and thank you, Hanifa, for yielding some time. I don't think I need the full 5 minutes to complete this thought on the landlord attestation issue. Really, any attestation that requires, I understand and appreciate that the amendment moves, right, there's now not a need for a written approval from the owner, but acknowledgement. I think still we're really close to a line of aiding and abetting, right? We're talking about federally illegal activity and something that landlords are really going to be unwilling to write and to engage in writing. And right, as we're thinking about centering equity and access in all aspects of our of this industry, and really making sure that small growers are able to participate. So few are owning the property where they'd like to grow, and I'd really like to see us spend some more time making sure we get this right. So my recommendation is twofold. One, that the acknowledgement, if there is an attestation piece, that specifically not reference a Schedule I substance. The landlords will not, whether it's acknowledgement or approval, or I think anything that requires a landlord to specifically endorse in some way the growing of a Schedule I substance on their property is going to be ill-advised. And secondly, I think it would be most beneficial to have a lease option for landlords and tenants who would prefer to keep all protective legal agreements within the actual lease, and the department could And the department could easily write a model lease agreement, which we'd be happy to offer and provide as an example and say, you know, this level of protection or greater. So those are my recommendations in general, right? Any access issues that we create at this early juncture in the department are going to have a foundational impact on the viability and the longevity and the actual equity that people experience within the program. As another note, just in general on compliance and cost, it may be helpful for the department to consider a cost analysis for some of the testing requirements that it's outlined, as well as the creation of a compliance guide, right? In addition to the rules that are promulgated now, we want people to comply, and the department does not want to enforce actions against cultivators. I presume we'd rather people comply. And so I'd like to recommend that in addition to the rules promulgated, maybe addressing resources that provide a compliance guide for people in these spaces. That's all. Thank you again, Hanifa.
Thank you.
And James Ferreira.
Morning, everyone. James Ferreira from Ignite Synergy, and so I wanted to just take a few moments to thank, you know, the Department of Health and Dominic especially for putting together this. Everybody has served in all the committees. The work has been incredible. The speed is unprecedented, I think, for state agencies moving on such a topic.
If I could interject for just a moment. You probably shouldn't be turning your head away.
Oh, sorry. Sorry if it's not receiving for everybody. One of the things that we've looked at as Ignite Synergy, the company that is an outcomes-focused software specifically built for psychedelics. We know that data collection is going to be an important piece of this, being able to actually say what our outcomes are, and we're forming a medical advisory board that we would like to just let people know. You can contact us and let us know you'd like to be on the board so we can make some really smart decisions about data and data management, so that when we do start collecting data, it will actually mean something. This is the first time humans have ever collected this kind of data, and we think it's really important. Thank you.
Thank you.
And the next individual is Gregory Evans. Mr. Evans, and while Mr. Evans comes on down to the mic, the next individual after this will be James Brown.
Nobody wants to go.
Please state your name for the record, and if you represent anyone, please let us know.
My name is Gregory Evans. I am an independent mycologist. I do not have any formal affiliations.
Thank you.
Nobody wants to follow James Brown. Okay. Bear with me. I have submitted, as of 8:44 this morning, a formal public comment. I will try to summarize that and hit the high points. First off, I want to thank the department, all of the committee members, everybody who's been involved for support and pushing this thing forward the way that we have. I do not like public speaking. I am here trying to do my best. So there's a couple things that I wanted to cover. Pardon me. The department adopted the 10% water content in the rule, and that is the correct direction. The water content measures total moisture. It does not measure whether anything can actually grow in the product. That would be water activity. I have a specific recommendation to include water activity at 0.6. If we do this, that aligns with the 10% in the control window. If we are at 0.6 AW, most of the testing panel for microbials will not be able to grow. And if we maintain cadence testing with water content and water availability, we will be able to reduce the cost to all parties with like a $25 sample cost. Like there's a lot more impact on that, but we can reduce the microbial testing by utilizing that initial release test and keeping storage within a constrained parameter. There were a number of items in the traceability section that required some refinement. There were areas where cultivation batch wasn't included in the lot hierarchy and other sections, so that lot hierarchy definitions are all mapped out in the recommendation. Among the definitions, I have 8 amendments. And on a high level, please let me know when I'm out of time.
So if you notice, he has a green card.
Okay.
That means you're still within your time.
Thank you, friend. You corrected a typo in inoculate, but I would like to move forward recommending inoculate means the process of introducing spores, mycelium, or spawn into growth medium. Inoculate is a verb and needs to be treated as such. I have a detailed recommendation on psilocybin. I'll let that stand as is. The difference between cultivation and manufacture, regularly through the ruling, they have overlapping scope. Noted. I have a detailed, in my item number 3, I've detailed how to clean that mapping and define the definition between the moment of cultivation and the moment of manufacture. Relating to traceability, in that section there is another definition of where unique IDs change from state change to state change. Basically, we were missing batch, and then when we become a harvest lot, the definition of that was ambiguous, so I've clarified that. Mycelium definition. Mycelium means the vegetative body of a fungus, composed of a network of filamentous structure called hyphae. Is that hard?
That's your time.
Thank you.
Thank you.
And Mr. James Brown?
Good morning.
Morning, sir, and everyone. My name is James Brown, and I represent 5 Degrees North Healing Foundation. Oh, sorry.
I can raise
Well,
this
thank
a
you.
little bit. Or actually, if you just want to take it out,
Is
that might be easier.
is that okay? I could probably do that. 5 Degrees North Healing Foundation. Is that better? It's a nonprofit here in New Mexico that focuses with veterans, first responders, PTSD, and other things. We're hoping to be a center that offers administration sessions, and for whatever that definition or terminology would be. I'm trained through Oregon, currently in a psilocybin-focused 12-week program that I think that would very benefit New Mexico to look at as we get through that program. And again, I just want to thank everybody here and the program itself. And Chris, give him some shout out for his time and effort, you know, to come up with this stuff and the chair of this. Again, public speaking stuff, so especially in this setting. So again, I'm here to really focus on some of my comments that I put in, and really just the 7.35.2.9, the general permittee requirements. And, you know, just to go back on that focus, and, you know, with New Mexico being such a rural such an amazing and beautiful state. But we're very rural, and we really got to think about that when we think about these rules, and just the thought and use a filter of that. And with this medicine that we're going to be providing these people the opportunity to experience something that maybe they've had experience with before, maybe they haven't. And these rules are a great start. And I think we've done a great job as a group. And thank you again for doing this today to allow us to come in front of you and present our comments to you. And so my focus would be on just that whole dual ownership. You know, my whole thing today is that, you know, to allow us to, the wording or, I really think we just focus on not saying and restricting so much of that language of saying you cannot own both, but maybe or. Because as a permittee, I think it's important to be able to have a center, but also maybe have a grow, right? As mycologists, you're gonna have these groups of people. And so you can have this great network that these people can tap into. And so within your own group, within your own business, I've owned quite a few businesses. And within that, you need opportunity to grow your business because you might have five people within your network, like in a nonprofit. And those people might be specialists in their groups. And within that, they might have a grower, a mycologist that's amazing. And so you need that opportunity. And so that would be the permittee there. But also I might have a provider who's a doctor. But within that same group, in that nonprofit, I want to be able to have a center. And so I just want to make sure that languaging in that dual ownership allows us to have that type of opportunity in New Mexico and also give other New Mexicans opportunities. Being so rural, again, Roswell, Farmington, little states, you know, we're only so big, right? And so there's only going to be so many providers, so many facilitators, so many centers. And so think about that. And so I just really want to open up that languaging to maybe the words of it being able to have the opportunity to have both, but not the laboratory and the grow, but just that thought. So thank you so much today. I do appreciate you.
And at this time, we have everybody who had signed up to speak on the sign-in sheet. We have gone through there, so if we can turn to the computer. If there's anyone who is on the virtual setting who would like to speak, if you would please raise your hand now, and we will go in that order. And we'll give just a moment or so for individuals to raise their hand. And just as a reminder to raise your hand, within Teams, it is, if you're on a computer, it is towards the top of the screen, the little hand icon, just simply click on it. If you're on a phone, it is usually in one of the lower corners, and just click on that item.
So if they call in, it's *5.
And if you are on a phone and not on a computer and just doing by audio, then it would be *5 to raise your hand.
I'll take this.
And we're just giving individuals a minute or so to be able to raise their hand. And I believe we have one individual at this time.
All right, first up we have John Dennis. And John?
What's John's last name?
Dennis.
Dennis?
Mm-hmm. All right, John, I've enabled your mic. You can speak when you're ready.
Okay, thank you to Dr. Zerlo and to the department for giving us an opportunity to comment on these rules. It's my great honor and privilege to speak to you today on behalf of the Psychedelic Bar Association and its New Mexico Working Group. Our working group includes 9 lawyers and legal professionals from across New Mexico and the United States who are volunteering their time to engage with and to provide input on New Mexico's rulemaking in order to help ensure that this program is the best that it can be. We submitted written comments, and today I'm speaking just to 2 of the points raised in those comments. The first comment I'd like to kind of highlight is our input on taxation under the Section 280E of the Internal Revenue Code. If the goal of the program is to keep costs to as low as they can be, Section 280E liability should be really minimized to the extent possible. for folks who aren't familiar with Section 280E, it's a tax rule that requires that any organization or individual who is trafficking in a Schedule 1 or Schedule 2 substance must pay taxes and is not able to deduct the standard deductions and expenses that they incur in the cost of operating their business. So with respect to how to minimize that tax liability, in the state of Oregon, in its psilocybin program, the common practice is for operators to bifurcate their liability so that those portions of their operations that are plant touching or mushroom touching that would be engaged in trafficking activities are maintained separately from the other aspects of the operations that are not plant touching, so that all of that liability can be sort of isolated and contained within as small a portion of the operations as possible. This kind of structuring that is pretty common. Not everybody structures their organizations that way, but many do, and it does substantially reduce the amount of tax liability that those organizations have. But there is an opportunity to go further than that, and that would be through allowing the direct manufacturer to consumer or patient sales. We understand that there is a very legitimate state interest in avoiding diversion and similar types of behaviors. And so we understand there's a series of protections and guardrails that should go around this. But if the facilitator or guide is not actually delivering the substances to clients or patients, that would enable those multiple hours, potentially as many as 10 hours per administration session, to not be taxed at this significantly higher level. So if the state were to allow some kind of abbreviated touch point with the actual transfer of psilocybin to the patient directly, it could provide an opportunity to save costs, reduce the tax burden that is a really significant aspect of this. It's more significant for those who are familiar with the way that 280E plays out in the cannabis space. With cannabis, it's just retail, so you're not really having to pay for hours of support and supervision and facilitation and that sort of thing. So the impact that 280E has on a regulated services model, such as New Mexico's, is significantly more than it is even in the cannabis space. So allowing these direct sales or some interim person who isn't otherwise providing like hours of services to the patient is a pretty good opportunity to keep costs low and keep it as affordable as possible under all the circumstances. The second point I wanted to speak to briefly is around
You have 30 seconds.
Okay, thank you. The written comments speak about the accidental, potentially the inadvertent authorization of religious use in the state of New Mexico by the passage of this Medical Psilocybin Act. We cite to 3 cases in our written materials that stand for the proposition that if the state of New Mexico or any state is authorizing legal psilocybin access for any reason, it then, under current U.S. Supreme Court precedent, must also authorize religious use of that substance. So the ask here is that you not disparage religious use cases, and that to the extent that this could result in potential harms that can come from community use in an unregulated or unsupervised setting, the state may wish to take action to ensure that there are safeguards and that there's
John,
some
that
kind of
is your time.
support. Okay, thank you.
All right. I'm not seeing any other hands up online. Just as a reminder, that should be, if you're on Teams on the desktop, up with a hand that says raise icon in the top bar. And if you are dialed in via phone, it would be *5 if you are not on the Teams app. All right, I am not seeing any hands raised at this time.
Well, that will conclude the public comments for the hearing today. I'll tell you a little bit about the process from here on out. I'm obligated to write a report that summarizes the written comments and summarizes the public comments that are given here today to the secretary, and then make a recommendation to her regarding whatever I think in response to the materials that have been presented. And that will be forthcoming after this hearing. I think, is there anything else we need to address?
I think that's it.
Okay. Well, thank you all for participating today, and at that point, we'll conclude the hearing and go off the record.
Thank you, everybody, and thank you, everyone, for